So this is back in the matter of People of the State of Michigan versus Jose Archer, docket number 20-50FH. And Mr. Cornish, you and Mr. Archer have now had a chance to consult privately, is that correct?
That's correct, Your Honor. I believe we're going to proceed with the hearing this morning or this afternoon. Quite specifically to Ms. Gallagher, he is not rejecting what she had brought up with us via emails, but he wants some time to think about it since I just laid it on him. So he wanted to proceed with today's proceedings.
Okay, so your motion, Mr. Cornish, go right ahead.
Thank you, Your Honor. Your Honor, most of my motion speaks for itself, but I had a few points I wanted to bring up. The first point I really want to bring up and focus on is the fact that this is the second issuance of this case. And why that's important is these two actually were back together and went on at least one, if not scheduled for a second vacation in this interim between the times that these were charged. So the prosecutor focuses a lot on my client being a danger and a threat to this individual, when literally they had gone out of state and flown out on vacation, were scheduled for a second vacation. And when the police came and decided this was going to be reissued, or when the prosecutor reissued it and the police came to get him, he immediately cooperated, went back into custody with them and did that. When he was on bond the very first time this occurred, he showed up to every court hearing, basically the same charges that he had previously that were dismissed. Showed up to the hearings, cooperated with his counsel like he's done in this case with me so far. This time it was different. He had this much greater bond placed upon him. And a lot of this is a factual dispute that we're not going to get into today, but it stemmed from other outside issues as the defense's position, such as my client dating other people. That was the very first thing. The second thing that I kind of want to bring up is about this whole COVID-19 thing and jury trials. What I'm hearing is we've met the 180 days. He's been in there actually longer than at this point, even if we count some of that time against the defense. But we have no idea when we're going to start running live trials again. I know that Judge Aquilina is experimenting with Zoom trials. In fact, I saw something going on today in that regards. But this is a much, I realize all cases are serious. This is a much more serious set of charges. And it's not something my client or I are even remotely prepared to consider doing a Zoom trial, which means that he would basically put in a position of sitting indefinitely in jail, not knowing when we're going to be running trials, or agreeing to some sort of a experiment with his very freedom on the line of Zoom trials. And I guess if we had like we're going to do a trial on September 1st, period, this is open, we're doing it, it would be different. But we don't. We don't know if they're going to, I just heard today that they extended everything through September for court closures. And we don't know if that's going to be extended again, if we're going to get hit with a second wave, if we're going to be sitting in here for a year waiting for a trial, a year and a half waiting for a trial. And I just don't think that that comports with the court rule and the intent to keep my client in there. And finally, Your Honor, I guess there are ways that the court can ensure my client does not interfere with this lady. He can be placed back on a GPS tether, which he had the first time. They can monitor his presence. And if he violates the court's order of no contact, the GPS tether would alert us, and the court can immediately have him put back into custody and not give him bond again. And so that is an option the court has within its authority to do and can do that immediately. So I think that it's appropriate today for him to be given a personal recognizance bond, and I'd ask the court to issue that. Thank you.
Thank you. Ms. Gallagher?
Thank you, Your Honor. In addition to the response that I filed with the court, a couple of points would just be that this defendant was originally charged, and then at that preliminary examination date, he did plead guilty to the PA-53, which was contact via phone, but the people couldn't proceed at that time without victim participation. I hear what defense counsel is saying, but respectfully, I do not feel as though if GPS tether would alert us of all violations of the no contact, especially when there's been admissions to contact that has been via phone or other means than in person. And further, Your Honor, I do think that I agree with Mr. Cornish in the sense that he was saying that when they were reissued, the charges, the bond was higher and the protection more heightened. And honestly, that was because of the fact that this defendant, while awaiting preliminary exam, interfered and contacted this victim, and then therefore we had to dismiss at that point. These are serious ramifications for the safety of this victim, the public at large, and also for the integrity of this case.
All right, thank you. Mr. Cornish, any last words from you?
Your Honor, again, just kind of responding to what she's mentioned here. The other contacts, as opposed to being in person, phone calls or text message or whatever, it can also be monitored and could be shown by the investigators or the prosecution if that were to occur after he's released. I think that's something that could be addressed by this court again as a violation of the no contact order. And rather than leaving him indefinitely in the county jail, I would ask the court to issue that PR bond. Thank you.
All right, thank you. Well, this is a motion brought under MCR 6.106 and 6.004, which provides that the defendant shall receive a PR bond after 180 days of delay unless the court finds by clear and convincing evidence that the defendant is likely to fail to appear or he presents a danger to another person or to the community. There has been more than a 180-day delay in this matter. I'd like to add at the outset that I do not intend to conduct any Zoom experiments for criminal jury trials, period. But I do have a trial date set of September 8th, and I'm planning on going forward. I'm unaware of anything issued today, but I've been on the bench, but I'm unaware of anything issued today that says we cannot do a jury trial on September 8th. And I'm having modifications made to the courtroom as we speak, and I intend to meet with counsel closer to the trial date to reassure you and go through all the steps that we're taking for everyone's safety. But other than the extensive safety measures that we would be taking, it will be a real live in-person jury trial. So there is that. But with going back to the court rule and the standard that has to be met, the defendant says that he's a longtime resident of Lansing, and that is true. I have a bond report that was previously done, and he's a lifelong resident of Lansing as far as I can tell. However, he's charged with first-degree home invasion, domestic assault and battery third offense, felonious assault, malicious destruction of a building, unlawful imprisonment, bribery or intimidation of a witness, and he's got a habitual second offender notice. All of these charges relate to his wife, Dora, and the prosecutor informs me in their response that Dora is afraid of him. Now, granted, perhaps they went on a vacation together in between the first issuance of the charges and the second issuance of the charges, but that's not uncommon in domestic assault cases, and it doesn't mean that Dora should not be afraid of him. He, in fact, has 2 prior domestic assault and battery convictions, a regular assault and battery conviction, and a conviction for assault with intent to commit armed robbery. So whether Dora knows it or not, Mr. Archer indeed poses a threat to her safety. Furthermore, Mr. Archer previously violated a bond condition and phoned Dora from the jail, which accounts for the added count of bribery or intimidation of a witness. So I appreciate that he could be monitored, but if monitoring does not stop him from doing something, if he's monitored when he makes phone calls in the jail, but that did not stop him from calling Dora from the jail. So I'm given little assurance that he could be monitored from having contact with Dora. And also the defendant says that he's been cooperative with the police when the charges were dismissed and then reissued. And I appreciate that, and that's generally a great factor that weighs in favor of he's not likely to fail to appear. But I still find that there is clear and convincing evidence that he presents a danger to another person or to the community, and for those reasons I am denying his motion for release on personal recognizance bond. And if there's
I'll email you over. I was just going to say
Okay.
I'd email it over to that nature here in the next couple minutes. Could you
All
tell
right,
me
thank
that
you.
trial date again, Your Honor? And if we were first up on that, I didn't see it on the docket.
September 8th? September 8th.
Thank you, Your Honor.
The docket's coming out soon. You haven't gotten a printed docket yet, but because it's a docket that begins on August 31. So I assume, because it has to go out 28 days in advance, that it's being sent out. It probably already has. I just haven't gotten it yet, but it's being sent out. I approved it.
Thank you, Your Honor.
Okay? Okay, Mr. Archer, you can tell them there at the jail that you are all set.
Okay.
Thank you, Your Honor.
Okay. Mr. Lyons, if you're there, and welcome back. Did you find your client?
Yes, my partner, as always.
Mr. Lyons, can you hear me?
I'm sorry, Judge.
That's okay.
I'm doing 10
Is your
things.
client?
No, I
Did your
talked to my
client-
client. I'm sorry, Judge.
Go ahead.
Have not used these delays yet.
I know.
Here's what's going on, Judge, and I apologize. Apparently, my client's dad forgot that he was supposed to bring her down here, and he went to a funeral. We do have, I think, a resolution, fair and equitable. I would ask for a very short adjournment, and I mean very short.
Okay. The problem is, I'm turning up the volume a little. The problem is, though, Mr. Lyons, I mean, I'll give you that, but you're the harder person to get a hold of than your client. So.
And I apologize, Judge.
Yeah, I mean, we'll pick a date and re-notify you, and you can get your client
I do
present.
thank the judge, the court, for giving me the dispensation that you have.
Sure.
I do appreciate that. And I will have Barbara give you a buzz, or I can give you a date right now, Judge. Or you
Well, I don't know my schedule, so you'll have to have someone give us a call and reschedule it.
Thank you, Judge. I do appreciate that, and I'll make sure that her and I are there in a timely fashion.
And
Okay.
Your Honor, I'd just like to let Mr. Lyons know that I will be out of the office this coming Friday through the next week, so until August 7th. So I would just request that if you submit dates to the court, please find a date after August 7th.
No problem. That would be after the primaries. That's perfect.
Okay. Well, good luck with your primary.
Thank you so much. Thank you, Your Honor.
All right.
Thank you. And that concludes all my hearings for today.